Imagine you have lived in the United States legally for years. You went through every interview, every background check, every fingerprint scan. You got your green card. You built a life, a career, a family. And then, the government announces it is reviewing your status again. That situation is now a reality for millions of lawful permanent residents in the United States. The Trump administration has launched one of the most significant immigration reviews in recent memory, targeting green card holders from what they officially call countries of concern. This is not a rumor. This is confirmed, documented policy, directly from USCIS, the U.S. Citizenship and Immigration Services. And by the end of this video, you will understand exactly what happened, which countries are on the list, who is affected, and most importantly, what affected individuals should do right now. Before we get into the policy itself, let's quickly establish what a green card actually is, because this is important context. A green card, officially known as a permanent resident card, is not a visa. It is not temporary status. A green card makes someone a lawful permanent resident of the United States. These are people who went through extensive legal processes, background checks, interviews, medical exams, years of waiting, and were formally recognized as being allowed to live and work in America permanently. That is why this announcement raised serious attention among immigration attorneys and affected communities. When the government announces it will re-examine the status of lawful permanent residents, that represents a significant shift in policy, one that has real, concrete consequences for millions of people's lives. On November 27, 2025, USCIS Director Joseph Edlow made a formal public announcement. In his own words, posted officially on the platform X, he stated, "At the direction of the President, I have directed a full-scale, rigorous re-examination of every green card for every alien from every country of concern." He added that protecting the country remains paramount and that the American people will not bear the cost of the prior administration's reckless resettlement policies. When reporters asked USCIS which specific countries were being designated as countries of concern, the agency pointed to a June 4, 2025 presidential proclamation, officially titled, "Restricting the Entry of Foreign Nationals to Protect the United States from Foreign Terrorists and Other National Security and Public Safety Threats." That proclamation, known as Presidential Proclamation 10949, established a list of 19 countries considered, in the administration's language, deficient with regards to screening and vetting. This proclamation was issued months before the Green Card Review announcement, meaning the policy framework had been building for some time. So which 19 countries are on this official list? According to Presidential Proclamation 10949, 12 countries face full restrictions. Those countries are Afghanistan, Burma, Chad, the Republic of the Congo, Equatorial Guinea, Eritrea, Haiti, Iran, Libya, Somalia, Sudan, and Yemen. An additional 7 countries face partial restrictions: Burundi, Cuba, Laos, Sierra Leone, Togo, Turkmenistan, and Venezuela. That is the official list as confirmed by USCIS and multiple credible news sources, including CNN, NBC News, and Axios. Now consider who lives in the United States from these countries. There are large communities of Cuban, Haitian, Venezuelan, Iranian, and Afghan origin lawful permanent residents across the country. People who have often lived in America for years or even decades, paying taxes, running businesses, raising American-born children. The scale of this policy is significant. Immigration law firm Jackson Lewis, commenting on the USCIS announcement, noted that the review will significantly tighten immigration scrutiny for individuals from the 19 designated countries of concern, and that affected individuals could face delays, additional interviews, or in some cases, re-examination of previously approved applications. The story does not stop at 19 countries. On December 16, 2025, President Trump issued a second presidential proclamation, Presidential Proclamation 100998, which expanded the travel restriction framework to include additional countries, raising the total to approximately 39 affected countries. Then, on January 1, 2026, USCIS issued a formal policy memorandum titled Hold and Review of USCIS Benefit Applications Filed by Aliens from Additional High-Risk Countries. This is a real official USCIS policy document, publicly available on the USCIS website, and it has major implications. This January 1st memo directed USCIS to place an adjudicative hold, meaning a processing freeze, on pending immigration benefit applications for nationals of all countries listed in the expanded proclamation. According to immigration attorneys at Grossman, Young, and Hammond, who reviewed the memo in detail, this hold applies to a wide range of applications: adjustment of status to permanent residence, employment authorization documents, advanced parole travel documents, naturalization applications, and more. The memo also confirmed that previously approved cases may be reopened and re-reviewed. Berkeley International Office, which advises students and scholars at the University of California, Berkeley, confirmed that the January 1st memorandum mandates that all aliens meeting these criteria will undergo a thorough re-review process, including a potential interview and, if necessary, a re-interview. These are significant, documented policy changes, not hypothetical. One concrete institutional step that has been taken is the establishment of a USCIS vetting center, announced on December 5, 2025. According to law firm Duane Morris, which published a detailed legal alert on the policy, this center is headquartered in Atlanta and is specifically responsible for conducting reviews of pending applications, as well as a more comprehensive review of already approved applications. The center will prioritize cases from countries designated as countries of concern. This is not a paper policy. It is a functioning agency with a specific mandate to re-examine cases. Duane Morris also noted several practical consequences flowing from this policy. Interviews for nationals of the 19 listed countries cannot be waived under any circumstance. Naturalization oath ceremonies, events where legal residents officially become U.S. citizens, will be postponed for affected individuals. Employment-based petitions for workers from these countries now carry heightened risk and unpredictability, and employment authorization documents have had their maximum validity period reduced from 5 years to 18 months for certain applicants. Let's be concrete about what this means on the ground. Immigration attorneys across the country have reported a range of immediate impacts on their clients. Green card interviews have been paused. Naturalization oath ceremonies have been postponed, in some cases with little or no advance notice. Applicants who had already cleared background checks and completed interviews are now waiting in an indefinite processing hold. For workers, the situation is particularly complicated. An employee from one of the affected countries who has a pending green card application through their employer may face months or more of delay, during which their work authorization situation could become uncertain if not properly managed. For people outside the United States, those going through consular processing to receive immigrant visas, there is an additional layer of difficulty. Even if USCIS approves a petition, the consular processing step may be stalled due to the travel restrictions. Immigration attorneys are also issuing strong cautions about international travel. Grossman, Young, and Hammond warned that travel outside the U.S. is extremely risky, even for those with advanced parole, and that there is a significant likelihood that affected individuals who depart the United States will be unable to return. This applies even to people who already hold a valid green card if their application for renewal or other benefits is currently pending. This policy has generated significant debate in legal and policy circles. On one side, the Trump administration and its supporters argue these measures are necessary for national security. The administration's stated position, documented in official USCIS memos, is that the reviews are designed to ensure that individuals from countries with high overstay rates, significant fraud, or both, are properly vetted, and that the immigration system must faithfully uphold United States immigration law. Critics raise a different set of concerns. Legal advocates and immigration attorneys point out that many of the people affected by this policy are individuals who went through legal processes in good faith, sometimes waiting years, and who have now established deep roots in the United States through employment, family, and community ties. There are also significant legal questions. Immigration attorneys have raised concerns about the retroactive nature of the policy, that is, re-reviewing cases that were already lawfully approved and finalized. The legal principle at stake is what lawyers call reliance interests, the idea that when a government agency tells someone their case is resolved, that person has a right to rely on that decision when planning their life. Law firm Jackson Lewis noted that the review process means individuals could face delays, denials, or even revocation of their legal status, and that benefits for non-citizens may be revoked. Their attorneys emphasize the importance of affected employers and employees seeking qualified legal counsel. For viewers who want the full picture of the expanded list, let's briefly go through the additional countries added under the December 2025 expansion beyond the original 19. New countries added to full restrictions included Burkina Faso, Mali, Niger, South Sudan, and Syria, among others. Additional countries were added to the partial restriction category, expanding the affected list to approximately 39 countries total, plus individuals traveling on Palestinian Authority-issued travel documents. If you or someone you know is from any country in sub-Saharan Africa, the Middle East, or certain parts of Latin America and the Caribbean, it is worth verifying whether your country is now on the expanded list by checking the official USCIS website or consulting an immigration attorney. The official policy document, Policy Memorandum PM 602-0194, is publicly available on USCIS.gov. Based on what immigration attorneys have publicly advised following these policy changes, here is what people from affected countries should consider doing. First, do not travel internationally without legal advice. Even if you currently hold a valid green card, if you have any pending immigration application, departing the United States right now carries serious risk. Consult a qualified immigration attorney before making any international travel plans. Second, gather and organize all your immigration documents. This means every USCIS notice you have ever received, every appointment confirmation, every approval letter, every receipt notice. If your case is reopened, these documents will be important. Third, if your work authorization is approaching its expiration date, begin renewal as early as possible. Processing delays under the current hold mean that waiting until the last minute could result in a gap in your legal authorization to work, which can have serious consequences for both you and your employer. Fourth, if your green card interview or naturalization ceremony has been postponed or canceled, keep records of the original scheduling. Document everything, including any communications from USCIS about the cancellation. Fifth, if you are an employer with workers from affected countries, consult with an immigration attorney now. Law firms specializing in employment-based immigration have advised employers to closely monitor the status of affected employees and to begin strategic planning for any visa or green card petitions that may be time-sensitive. Sixth, monitor the USCIS website and official policy updates regularly. This situation is evolving. New memoranda can expand or modify the policy at any time. The USCIS Policy Alerts page is the authoritative source for changes. It is worth understanding that the Green Card Review Policy is part of a broader set of immigration changes under the current administration. According to USCIS policy documents and legal analyses, the maximum validity period of certain employment authorization documents has been reduced. A new USCIS vetting center has been established specifically to conduct security-focused reviews. Mandatory interviews are now required for all applicants from the 19 listed countries and cannot be waived. And the public charge rule, which allows immigration officers to weigh whether an applicant might use public benefits in the future, has been strengthened. Immigration policy analysts have noted that the combined effect of these changes is to make the process significantly longer and more uncertain for nationals of the affected countries, even for applicants who have clean records and have lived lawfully in the United States for many years. What is unfolding in the American immigration system right now is, by any fair measure, a significant policy shift. Millions of people who followed legal processes, who were formally approved for permanent residency, who built lives and careers and families in the United States, are now navigating a level of uncertainty that many did not anticipate when they first received their green cards. The administration's position is that national security demands this scrutiny. Critics argue that the scope of the review raises serious legal and humanitarian questions. That debate will continue, and legal challenges are widely expected. What is not in dispute is that the policy is real, it is in effect, and it has already begun producing tangible consequences for people, families, and employers across the country. If you found this breakdown helpful, please like this video and subscribe so you don't miss updates as this story continues to develop. And if you or someone you know has been directly affected by these policies, leave a comment below. This is a community where information matters. Remember, if you are personally affected, always consult a qualified immigration attorney. This video is for educational purposes only and is not legal advice.